just have a look through it. We'll do it now. Just 5 minutes. Just 5 minutes. Please. So in CLRI, the topic that we are going to cover today is judiciary. Okay, and I'm requesting you to read it through, give it others the opportunity to come. Okay, there are many people who are on their way. In the meantime, you can read this material. Right, let's start judiciary. We'll do that part later in our next class, next segment. Under judiciary, we are going to look at various aspects. First aspect is the constitutional significance of judiciary. Then we will look at judicial appointments. Then judicial bias. In fact, judicial bias will do position of judiciary. We'll do judicial bias.
Sir, public CLRI election structure.
Yeah. And lastly, we will do training of judiciary. So these are 5 aspects of judiciary. Okay, that we are going to cover. This should cover our both public and CLRI. Okay, so if we do all 5, it should be fine. Okay, this should cover our chapter in public law as well. Okay, and all these things, especially especially this one, and this one will be looked at from the point of view of the Human Rights Act. So mainly class HRA 1998 implications. This is what we are going to cover under this chapter. So 5 aspects of judiciary we are going to cover. One is constitutional significance of the judiciary, then judicial appointments, the composition of the judiciary, judicial bias, and training of judiciary. And all of them will have to be examined in light of the Human Rights Act. Am I clear? Everyone?
So start out looking.
These are more linked with Human Rights Act, more directly linked with Human Rights Act. Now, interesting thing, it won't be too difficult for you because most of the elements here were covered the initial level, and also when we have done the separation of powers. Okay, that is covered by those chapters as well. So it's, you will feel some of the things, some of the areas you will feel more like a repetition. Okay, but this can be very crucial for examination. This is something I would like to think very crucial. Sometimes we have seen questions are coming from this one plus HR 1998. Okay, so a question can come linking this aspect, judicial appointments and judicial training in light of Human Rights Act. That can be one question. Okay, so and it's a very good question to answer, I would say. Now, are we clear? Now, let's look at the constitutional significance. Can you take notes, please? We are now, those who are online, for them, we are going to look at the constitutional significance of the judiciary. Okay, what is expected from the judiciary under the UK Constitution? In fact, what is expected from the judiciary under any country's constitution? What kind of judiciary would you expect? What kind of judiciary you would want? You would want the judiciary which is to be independent and impartial. So the constitutional will have to have mechanisms to ensure that these two key elements are present, isn't it? So the constitutional arrangements will have to be such that we have these two features, these two elements of the judiciary are present. Otherwise, the judiciary is not going to play the role that is desired from the judiciary. Are we clear? Okay. Now, what are the things that is needed if we want to ensure, if we want to have a judiciary which is independent and impartial? What do we need to make sure? We need to make sure that their appointments are done by whom? Done by the executive or done by an independent body? It will have to be done by an independent body. So that's one element we have to examine. We have to examine what about the tenure of their job, is it easier to dismiss a judge? Who can dismiss them? Okay, if their job is under someone who is a political person, or if the executive can remove a judge whenever it likes, will that ensure independent and impartial judiciary? The answer is no. So security, the tenure of their job, the security of their tenure, is very important. Okay. Lastly, the very important thing is the immunity of the judges. Can you sue a judge for giving a wrong decision? No. Can you sue a judge for giving a par incuriam decision? Can you? No, you can't. You can appeal. You can appeal to the higher court, but you can't actually sue a judge. Why can't you sue a judge? Why they should have the immunity? Yes, because if I am the judge and if I have to think about the future litigation, if I'm afraid that whatever I give I may be sued, will I be able to think and apply the law independently, freely? The answer is no, I can't. So the constitution must guarantee these things. Otherwise we will not be able to get a judiciary which is independent. You can't. If there is an option of suing a judge, the judge will always have to think, how do I do it? Well, that's a good point. I really want. Somehow this thing went out of the track. He can't do that. He can't do that because he is not a party. That was quite surprising. Somebody told me, this is off the record. Somebody told me that these lawyers' license should be cancelled. Not only that, the senior's license should be cancelled. Because who would take? So that was a big question. True. You can't do that. That was very surprising. You can't give judge a legal notice like that. So are we clear? So this is something that needs to be looked at. Now many of these things we know, we have seen it in separation of powers. Then once we are done with the constitutional significance, we are going to look at the judicial appointments. Why I'm bringing that here? Now, you see, we know that there was this piece of legislation has changed everything in terms of judicial appointments, in terms of how the judiciary works. A lot of things have changed because of this piece of legislation. And we also know that there are new institutions in place because of the Constitutional Reform Act 2005. Now, think about it. What should we look at the judicial, when we are looking at that part of judicial appointments? Should we look at the new judicial appointments process, or should we look at the reason for the new judicial appointments? Okay, now if we prepare ourselves just for the judicial appointments process, everyone will have to write the same thing because the process is a process. Not much to write there actually. So I always prefer, and this becomes very effective, that we also look at the reasons for the new judicial appointments. That means what we will look at what was the judicial appointments before 2005, what is there now after 2005, and what is the reason for this transition. You see, we had one process in place, we shifted to a new process. There must be a reason, there must be good reason for that. Okay, what is that good reason? What are those good reasons for shifting the policy, shifting the process? Okay, and did it really help? Okay, and that is when we are looking at the did it really help? When we are looking at the impact of the new judicial appointments process, we have to then bring in the social representativeness of the judiciary. Because one of the ideas of having a new judicial appointments process is to change the complexion of the English judiciary. English judiciary was, characterized as white, male, middle class, middle-aged, conservative. Okay, that complexion needed to be changed to increase the confidence of the society. Okay, that is when it became very important. And we can, if we look at the impact of CRI 2005, we have to discuss those things. There is a concentration of having too many male judges, less number of female judges, less number of black and ethnic minority judges. All those issues are linked with this. Are we clear? Yes. Okay. You see, one aspect is very clearly linked with another aspect. Okay. Then sometimes questions come that how the new judicial appointments process became such a crucial thing because of the Human Rights Act 1998. That means we have to discuss, we have to bring in human rights aspect to justify the new judicial appointments process. Okay, that's another area. I have seen even questions asking about the justification of judicial training, especially after the Human Rights Act, or how judicial training has changed. The pattern of judicial training has changed after the Human Rights Act. Okay, how crucial it is that that judges, at all stages, starting from the magistrates courts to up to the Supreme Court, even the top judges, how crucial it has become for them to be trained on human rights issues. Okay, so training and human rights, again, an important issue here. Are we clear? Okay. Last thing is judicial bias. Quite a bit of work to do here. Judicial bias, you can link that with what we have done in jury. Okay, especially the new appointments process in jury, where the new eligibility of the jury, where those who are involved in the administration of justice are allowed to serve as a member of the jury under the Criminal Justice Act 2003. Okay, those are crucial issues to discuss under that. Are we clear? Okay, so quite a bit of work, but this is going to cover our both chapters in public consideration. All right, let's take some notes. The judiciary is the third organ of the state which is expected to be independent and impartial. And dispense justice which is an important right of citizens. Full stop. The Constitution of UK is the Constitution of UK provides a judicial process where the judges are deemed to be independent and impartial. Even though there are debates about it. The judges, new para. Traditionally, under the Constitution of UK, the judiciary is the core institution to administer and uphold the rule of law. That means the administration of justice and the protection of rights of the citizens are provided by the judiciary. Although the Constitution acknowledges the supremacy of the Parliament, as a general principle, but the role of the judiciary is very important for the protection of individuals' rights and freedoms. New para. In order to ensure an independent and impartial judiciary, in order to ensure an independent and impartial judiciary, the judicial appointments in order to what is the line?
Ensure impartial and impartial judiciary.
Independent and impartial judiciary, the following three elements. Again, the following three elements.
Independent and impartial judiciary.
The following three elements must be available through constitutional process. Number one, the judicial appointment process. Judicial appointments process by an independent commission Number two, the security of tenure. The security of tenure. Number three, the immunity of the judges. Judicial appointments. Under constitutional arrangements of UK, the judges used to be appointed by the Lord Chancellor's department. However, there is now a new judicial appointments process. There is now a new judicial appointments process. Which involves an independent judicial appointments commission. Which involves an independent judicial appointments commission. and also encourages women, comma, black and ethnic minority people to apply for the judicial office.
Judicial office.
The idea behind the new judicial appointments process is to enhance confidence of the society into the judicial process. Full stop. New paragraph. Under the Acts of Union, sorry, not Acts, under the Acts of Settlement, (1700), the judges are not easily replaceable. That means the judges must be given security of their job. And cannot be dismissed without the approval of the Parliament. So, just one correction, it's Act of Settlement 1701. Act of Settlement 1701. Which means that a judge can only be removed from his office on the ground of serious professional misconduct with the approval of the Parliament. I took money as bribe, there was a clear conflict of interest in dealing with the case. Things like that. But then he can't remain in office anyway. If he then he can't be fit for any job. That would be that we are betting on, yes. Not a functional misconduct. Alright. Okay. Are we clear so far? Let's move on to the next one. The judges are immune from, third point, the judges are immune from any future legal issues. That means no judge can be sued for a judgment which was given erroneously or negligently. Negligently. Such immunity is given to judges. Immunity is given to judges to ensure that they can apply their mind freely without thinking of any possible legal consequence, any possible personal legal consequence. Possible personal legal consequence. Full stop. It also ensures that as an individual, the judge can perform his duties fearlessly. So, new paradigm. In recent times, UK judiciary has gone through lot of changes due to the Constitutional Reform Act 2005. Under CRA 2005, there is now an independent judicial appointments commission. Which is now responsible for the selection and appointments of judges. So this is viewed as a major step towards judicial appointments. Sorry, towards judicial independence. Because previously the process was entirely controlled by the Lord Chancellor's Department. It is widely acknowledged that the new judicial appointments process confirms the doctrine of separation of powers where the judiciary is independent of the influence of the executive. Stop. That's it. That's your constitutional significance. Okay. You can look at the case, at this case. Have a look at this case, please. Take note of it. Those who are online, take note of this as well. M versus Home Office. Okay. So I conclude this class here. I'll be back for public law class shortly, and we'll do revolution.